Welcome to the NeLI Pod podcast. Today we have the distinct privilege of speaking with someone I personally deeply admire and respect, the Honorable William Matthewman, United States Magistrate Judge for the Southern District of Florida. Judge Matthewman has been a prominent figure in the legal community, known for his keen insights on the intersection of law, ethics, and technology. He's not only presided over high-profile civil and criminal cases, but he's also authored significant thought leadership pieces that address the evolving ethical obligations of attorneys in the digital age. His law review article from a couple of years ago made a profound impact on Brandon, myself, the entire legal community, emphasizing the critical need for technological competency and awareness among attorneys, a topic that couldn't be more relevant today as we grapple with the rapid emergence of generative AI and other disruptive technologies. Judge Matthewman, thank you so much for joining us today. It is such a privilege to have you with us.
Well, thank you very much, Daniel and Brandon. Good to talk to both of you. This is an important area of the law.
Well, that's a great place to start. Now, I mentioned in the introduction, Judge, that in 2020, specifically November 2020, that you had this University of Florida law review article, and it was called Towards a New Paradigm for E-Discovery in Civil Litigation, a Judicial Perspective. And you talked about these 10 tenets in this article. And I want to take a moment to just read for all of our listeners what those are, because I want to dig into this as our first question here. You talk about, number one, proper and timely preservation of potential discovery materials, prompt and complete initial disclosures as mandated by Rule 26A1, targeted and precise discovery requests to avoid unnecessary breadth, complete discovery responses that eschew boilerplate objections, professionalism and cooperation among counsel, including honest good faith discussion to resolve disputes, limitation of discovery to what is relevant and proportional to the case, early involvement of in-house IT professionals to navigate technical aspects of ESI, utilization of e-discovery vendors and experts when necessary, greater reliance on TAR, including the use of search terms, sampling, and artificial intelligence, and finally, active judicial case management to oversee and guide the discovery process effectively. You know, I read this, Judge, and I think that this is the mantra. This is all we actually need. The rules are like icing on the cake, but this is really all we need. Now, you wrote this at the end of 2020. And my big question for you, Judge, to start us off with is, are we close to these top 10 tenets, the 10 commandments, I'll call them, of e-discovery that you wrote? Are we close to getting there, or are we not even close yet?
Well, I think we're closer to getting there. We're not there yet by any stretch of the imagination, because the 10 core components have different areas and different involvement and different actors in those roles. But I do think we're getting closer. I think we're getting, people are getting more experienced in this area. You know, I often say that it's technology that got us into this mess, and I think it's technology that will help us get out of this mess. And I say that because we live in a world where there's just so much data out there. So the idea behind the article just really came from handling, you know, hundreds and hundreds of cases and discovery disputes and trials and all types of things, trying to crystallize what really the top core components are to have effective e-discovery in this modern age. So I think we're getting better. We're making improvements. I think counsel and judges and litigants are more experienced now, but we're definitely not there yet.
Well, Judge, building on that, there were a couple of those specific tenets that you listed there, talking about the increased use of TAR and specific types of technology that are being used there, and then a more active role by judges in pushing for the use of technology in pushing e-discovery matters forward. I'm curious what you think the role of the judiciary is in raising the awareness amongst the bar of what technology solutions are out there, advocating for technology solutions, or even requiring certain technology solutions in the e-discovery process.
Well, I think it's important for the judiciary to have a role in making sure that these cases are litigated in a fast, expedient, and fair manner for everybody. You know, Federal Rule of Civil Procedure 1 talks about that goal. And the only way you can really achieve that nowadays is if you effectively harness and use ESI and e-discovery and these concepts in the modern discovery age. You know, the days of going to somebody's warehouse and looking through boxes of documents, those days are gone. You know, everything now just about is ESI. And I think that as judges, we have to become aware of that. We have to educate ourselves on modern e-discovery and ESI and all those topics. But we also have to encourage the litigants and the parties and the attorneys to join in as well. You know, in my scheduling conferences that I have in most every case early on, I always explain to the lawyers what's expected of them. I expect them to be competent in the e-discovery area. I expect them to be professional and cooperative, and all the other requirements that we expect. And the article that was written was more a judicial perspective, what we as judges would like to see from the parties and the lawyers involved in these cases. So I think we have a role in learning ourselves and also making sure that the bar is aware and is actively participating in proper handling of these cases, because you know it's important that lawyers be a very good advocate for their clients, but it's also important that in the discovery process that there's a lot of cooperation, professionalism, and a lot of discovery disputes can be avoided if the parties will just get together and confer properly, act professionally, and use some of the technology that's out there to make the discovery process, the search and production, a bit easier on everybody.
You know, I love what you said there, because I think that's one of the challenges that, you know, from the outsider view that we see that a lot of lawyers have this obligation under Rule 1.1, Comment 8, to understand the risks and the benefits of relevant technology. But I'm wondering, Judge, do you believe that this obligation extends beyond basic competency? In other words, if an attorney is in a case management conference with you and they say, well, sure, you know, I've got some ESI, I've got emails, and that's it, right? And that's all they know is that ESI equals emails. With other technology that is here and not going away, with generative AI, ephemeral messaging, hyperlinked documents, to what extent do you think that the attorneys have to really truly be much more knowledgeable than just surface level? Like, do they need to get into the weeds with this, or what is the ethical obligation from your perspective, Judge?
Well, you know, I look at it a couple different ways. Number one, if I was the client, I would want an attorney who's very well versed in this area. You know, it's no longer just text and emails. I mean, a competent lawyer needs to understand Slack, WhatsApp, Teams, you know, all these types of platforms and ways to communicate. So if I were a client, I would want my lawyer to know that, and I would think that, you know, parties in litigation would want their lawyers to be very, very up to date on the technology. Now, from an ethical point of view, you know, it's hard for me to understand how a lawyer could zealously represent a client as they're supposed to without understanding more than just a basic knowledge of ESI or e-discovery. I mean, I can remember years back, and I haven't had this happen in many years, but I can remember lawyers, you know, appearing in court and saying, well, Judge, I don't understand all this e-discovery stuff, but, you know, I know everything's been produced. And it's, you know, that may have worked 10 years ago, 15 years ago, but it doesn't work now. So I do think that lawyers, not just to do their job well and to represent their clients well, but also to fulfill their legal and professional and ethical duties, I think they have a duty to have much more than a basic understanding of, you know, emails and text. I just think it's, in this day and age, it's absolutely essential for lawyers to grasp that and to continue learning it too, because the platforms change, the ways to communicate change, everything evolves. You know, now we're getting into things like predictive analytics and search and production. I mean, these things it's a constant learning process. I find myself, trying to educate myself and learning e-discovery and ESI and all these other things on a monthly basis because there's so much new that is coming out. How to handle hyperlinks, how to handle all these other things that are out there. So I do think that lawyers have an obligation to go beyond the basics.
That's a really interesting answer to the question. And we're talking about a couple of different things here. There's one, attorneys needing to be aware of the things that are out there, data types, challenges with data types. But there's also what processes do we use to deal with these challenges that we're seeing. And it feels like the definition itself of competency is evolving a bit. It's progressing along with the way the technology progresses, but it's also evolving in that there's more in the realm of what you need to be competent about than there used to be. And I'm curious what you think about that idea that how does an attorney know that they are keeping up with their ethical obligations of being truly competent when there's so much to learn out there and there's so much to see? Is there a way for them to measure that or something they need to keep their eyes on to be able to say, I'm really fulfilling my obligations here?
I think, first of all, they need to attend the appropriate seminars and CLEs and other programs that are out there. And I think on a case-by-case basis, they should be able to understand where they're deficient and where they're not deficient, where they're up to speed and go ahead and educate themselves on those areas that they are lacking on. And then if for some reason counsel just doesn't have the ability to educate him or herself or to bring himself or herself up to speed, I think they need to engage in an IT professional, an ESI vendor, an ESI expert, to assist them in the process. And after going through a few cases with perhaps an ESI vendor or ESI software or an IT expert or other type of expert, by osmosis, they're going to learn the process a little bit more. So I think that's very important. I also think that in-house counsel for large corporations are going to be insisting on lawyers being up to speed on the e-discovery aspects of their cases because it's a very expensive area. Discovery is a very expensive part of litigation, and the more it can be made more expedient, quicker, fairer for both sides or all sides, and less time consuming, the better it is really for everybody because it moves the case along much quicker.
I love your answer so much. One of the seminars that I think everyone should attend also happens to be the NeLI seminar that's happening in Kansas City in September. And you're right, Judge, and I feel like there's so many opportunities for attorneys to advance their education by attending various different webinars, seminars, in-person conferences. And I really do think it's incumbent upon them. And one of those areas that we're going to transition and talk about now is what everybody's talking about. You can't have a podcast episode without talking about generative AI and e-discovery. And one of the things that Brandon and I have heard from other judges and other attorneys who have been on the NeLI Pod podcast is that it is really transforming the legal landscape. We are really at this inflection point and it's not hyperbole, right? We are at this inflection point. We're finding multiple contextual ways in which to utilize Gen AI. But one of the challenges that we are seeing is that the federal rules of evidence probably is not going to evolve as fast as or keep up with as fast as the Gen AI technology. And I'm wondering, is that okay, Judge? Can we draw from other precedents from the courts to where we have seen other technology shifts throughout time, such as authenticating handwriting or authenticating photographs and metadata and digital contracts and photos? We've grappled with this idea of authenticating evidence before, even with the existing federal rules of evidence. And I'm at this point kind of scratching my head, and Brandon as well, is about, can we do the same thing with generative AI? Can we just use federal rules of evidence as they exist today? Or what are your thoughts about this, Judge?
I think, and I've given this a lot of thought over the last year or two. I do think that, first of all, this is one of the reasons lawyers have to be competent in this area because, it's up to the lawyers if they're shown a photograph or a video or some sort of generative AI, it's up to them to have the technological expertise or have an appropriate expert to look at that document or that video or that photograph or whatever it might be to make sure that it is legitimate and properly authenticated. So, lawyers for the parties bring the disputes to the judge. Okay, we have so many cases, we don't go through our cases to see what might be some sort of fake photograph or fake document or something of that nature. So the first thing is the lawyers have to be competent enough and on the ball enough to make sure that they bring these challenges to us when they're appropriate. And the only way they can do that if they understand generative AI and if they understand all the different ways that it can be used. I do think that the current federal rules that require authentication and that require evidentiary foundations for the admission of evidence, I do think that they can be used well in this area. But it is up to the parties and their lawyers to bring the challenges to the judge in a timely manner so we can address the issue using experts, perhaps declarations or affidavits, making sure that they bring the challenges to us. And I think that's why competence is so important, because if an attorney is not competent in the area, then some sort of fake document, fake photograph, fake video, whatever it might be, could be passed off on them and entered into evidence. So I do think our rules are pretty well designed to authenticate all types of evidence, including anything that may be developed through generative AI, but it's up to the lawyers to make sure that they check it out and they bring those challenges to the court.
Another place that we see Gen AI talked about very frequently in the field of e-discovery is the use of Gen AI to replace first-level document review. A lot of people seem to think that Gen AI is just the next step on this linear path of the use of technology in what is essentially search and retrieval across huge volumes of documents, from keyword searching through TAR and now to Gen AI. So a couple of questions. First, do you think that that's accurate? And second, do you see any particular issues with the way in which we would supervise Gen AI tools in doing this sort of work and replacing humans and doing first-level review?
I think it's another tool that can be used for document search and production. There's nothing bad about AI or generative AI in and of itself. All these tools, whether you're talking about technology-assisted review or any other tool, when they first come out, they create a lot of confusion and a lot of people have a knee-jerk reaction against them. But there's nothing wrong with using these tools and the new tools, generative AI, for proper search and production. But they do have to be supervised by counsel, and that's really the key that is here. As I said, there's predictive analytics coming out. There's generative AI. There's all types of search and production tools that will make it easier on parties and attorneys to find the relevant and proportional documents and avoid all the junk and wasteful discovery. I think one way to protect when you're doing this process is you should have a 502D order in place in case confidential privileged documents end up getting produced. I think that is important. I think an ESI protocol in the right cases is quite important. But I don't see any reason why you can't use generative AI for proper search and production, so long as it's properly supervised and so long as it is made to work properly in the case.
I love that, and I want to make sure that the masses of legal professionals that are out there, hear this one particular episode, because what you're saying is fantastic, and also for all of our listeners. Also, I believe you're alluding to the Rules of Professional Responsibility, Rule 5.3b, that says that a lawyer must supervise non-lawyers, and in some sense, we're talking about Gen AI being able to be perceived as being like a non-lawyer. It's producing either case law that you have to make sure that it's not a hallucinated case law, or coming up with, and I'll put in air quotes, responsive documents. But, again, but Judge, to your point, you have to be able to review before it gets sent out the door, which brings me to my next question, which is young lawyers. So, it's interesting. So Brandon and I are of the cloth where we started off with many lawyers probably listening to this, with banker boxes. And we started, as Brandon has heard this story several times over, on my desk was not a computer, but a dictaphone. And so, I learned the fine art of dictating, and this wasn't that long ago. I mean, it was. Yeah, it was. Okay, it was over 20 years ago. It was. But regardless, one of the things that I see is that as we advance in technology, and now in particular with Gen AI, I worry with the young lawyers that it went from not having to go through the books, and you go through LexisNexis or you go through Westlaw or any other online research database, and it became remarkably easier. You don't have to go to the law library. There was a convenience there. Now with Gen AI, it almost seems like, well, I don't even need to go on to an online research database, and I don't even need to read documents inside of an e-discovery platform because, gosh, the Gen AI is just going to do it for me. How do you see that, Judge, as far as, am I doomsdaying this too much for the next generation of lawyers? What does the bench think about this?
Well, I think it might be a little bit too much doomsdaying, but there is a problem there. Lawyers cannot simply, new lawyers especially, rely on AI, generative AI. They just can't. They have to do the hard work first. No matter what you do, you have to do the hard work first. That's what gets you to be successful. And the hard work is reading the cases, doing the research, knowing the facts of your case, speaking to your client, all the other things that go into being a good lawyer. And if it turns out that lawyers are simply relying on generative AI to prepare their case or to do what they need to do, they believe in their case, that's going to be a big mistake because, we've seen a bunch of hallucinations. They're not going away. I spoke to a judge recently in the last month who just had another set of hallucinations. The lawyers have to make sure that they put in the hard work, they read the cases. AI can be a tool to assist them. AI could perhaps help them in drafting a motion or working out case strategy, or maybe suggesting questions to use at a deposition. But that's where it stops. They then have to take control and make sure that all the cases cited are correct, all the citations are correct, that the questions won't open the door to something that they don't want to come out, all the other things that good lawyers strategize about. So I'm hoping that young lawyers, with the high level of technology, everybody's always on their cell phone and everybody's always connected. I'm hoping that they won't forget that they still have to do the hard work and that all these other tools are merely to assist them in doing the hard work, not to replace the hard work that they have to do if they want to be good lawyers and good litigators.
I think that's a great answer and a great hope for what the legal industry does with these new tools. And I think there are so many different ripples to what Daniel was asking about, the ease of research and the ease of sort of putting some of the burden of building your arguments and things like that onto an AI instead of doing it yourself. In somewhat of the same vein, do you see this having an impact on law clerks and the need for law clerks and the ability or opportunity of young attorneys or burgeoning attorneys to have that experience as a law clerk and really learn that deep reasoning and analysis that comes from research and comes from reading arguments? Do you think AI is going to get in the way of that or help assist that?
I think it'll probably help assist. I mean, law clerks are very important, and AI will never replace law clerks. I mean, my law clerks are so important, and you talk to any judge, the law clerks are just key to what we do because they are so important. And the good thing about being a judicial law clerk is, you have to stay within the parameters. In other words, when we have a case, we look at the case and the facts in that case. We can't use generative AI or some sort of AI to go beyond the facts out into some public arena to get information. We have to rely on the facts of the case and the law applicable to that case. So again, will generative AI be able to assist law clerks? I think it probably already is. If you use Westlaw, you're using some form of generative AI. If you use Lexis and all these other tools, I think you're using some form of artificial intelligence, right? So if that's the case, there are other ways that it can assist law clerks. But I really do think that the unique role of law clerks assisting judges and having ethical requirements to make sure you stay in your lane, you don't go out into the public arena for information, you stay only dealing with the facts that have been brought to your attention in that case. I think that gives law clerks a head start on future practice, because that will teach them that they have to focus on the facts at hand and the law applicable to that case. But I do think that AI, generative AI, I think it can be of assistance to not just lawyers practicing out and litigating, but also to law clerks. I don't see why not, again, so long as it is properly supervised.
So you mentioned how Gen AI is going to be useful to law clerks and useful to lawyers. I'm wondering about equal access and equal justice to the law. One of the things that I'm identifying as part of some of these trends with Gen AI is now all of a sudden pro se litigants now have the ability to be able to have the law at their fingertips, so to speak, much more so than a paid online database. And I'm wondering, do you think because Gen AI does give access to case law, it gives access to statutes and codes, but it also gives access to even drafting, right? And so all of a sudden you have all these drafting capabilities that weren't there before, whereas, and I remember seeing this as a law clerk myself with pro se litigants, memoranda and what their motions were like, and it obviously wasn't, written in the way or the context and way in which a lawyer typically would. Do you think that this is the greatest equalizer of providing equal access, justice to the law, because now everyone has access to the same thing?
Yes and no. At least with attorneys who misuse AI, you have some ethical supervision and legal supervision. When it comes to pro se parties and litigants, and pro se parties and litigants are important; they deserve their time in court. But I am concerned that pro se litigants who are not schooled in the law, who don't understand fully the ethical obligations that are attendant on prosecuting or defending a case in court, that they will simply rely on some of these online AI tools or generative AI tools to draft motions and consider that whatever is said in there, is the Bible, when we know it's not. And I am concerned that pro se litigants will have more hallucinations than attorneys would, because I do think attorneys are learning more and more that they have to supervise whatever tool they're using to make sure that their cites are correct. I don't know that's the same with all pro se litigants. So that part does bother me, and that does concern me. And I don't know how you deal with that other than we, on a case-by-case basis, or perhaps in orders to pro se litigants, we put in there to make sure that if they use any type of tool, that they have checked it before they file to make sure that whatever is in there is accurate. Because I do think that is a concern. So on the one hand, I believe it can open up the law and help pro se litigants, but I also think it can be severely abused and misused by pro se litigants as well.
Judge, you've said in a number of different answers that you've had to questions about this advancing technology, you've talked about supervision, you've talked about the responsible use of these AI tools as tools and not as a replacement for things that we've done before. One of the things about the legal industry is that it really is built on a tradition of rigorous research and reasoning and working out arguments in order to present them to judges. What would you give as advice to law firms and to young lawyers as to how to make sure that they're balancing the growth of those skills and the maintenance of those skills rather than relying on AI to do some of this for them? Is there a way for organizations to make sure that their young lawyers are still growing in that way?
I think so. I think there's a lot of things that can be done. I tell lawyers all the time, young lawyers especially, when you get a case, if you're prosecuting or defending it, the first thing you should look at is the jury instructions. Pull out the jury instructions for the causes of action in the case, and they'll look at the elements, and those are the elements that you have to either prove or defend against. And that's where you should focus your discovery and your efforts. So that's one thing. But I think a good lawyer, what does a good lawyer do? He or she communicates, right? They evaluate, they strategize, and then they litigate. That's never going to change, no matter what tools are out there. You have to be able to a good communicator with your clients, with other lawyers, with other parties, and with the court, with judges. You have to do that. You have to evaluate your case correctly. Some lawyers have a tendency to, if they're plaintiffs on the plaintiff side, it's pie in the sky. This case is going to be worth so much. And other times on the defense side, this case is worth nothing. And they're not always right because there's not always a proper evaluation. So young lawyers need to learn how to communicate. They need to evaluate their case. And then it's really important to strategize. And while I think these tools like generative AI can help in strategy, they can give suggestions. They can assist in what might be effective strategies in the case. But the lawyer themselves, they are the ones who have to make out what the strategy is. And then they have to figure out what is the effective way to litigate for their client. Once they've done all these steps, what do I need to do to litigate for my client so we get a successful resolution? And that doesn't mean fighting everything. It doesn't mean objecting to every single thing. It means to only fight the important fights and the other things to cooperate and be professional about. So I think young lawyers are at a very interesting time. I think they're getting more tools than the older lawyers had when we all started out. They have a lot more assistance that's coming their way. Like you, I started out with going to warehouses and looking at boxes. Sometimes I would bring my own copier with me to copy documents, so I wouldn't let the other side know what documents I was copying. I can remember using dictaphones. Those days are long gone. So in many respects, it's a much better time for young lawyers. But they cannot forget the essentials of what it means to be a good lawyer. And that is a lot of preparation, a lot of hard work, a lot of research, a lot of communicating, evaluating, strategizing, and then figuring out the best way to litigate your case to get the result your client wants. And I don't think that's ever going to change. The tools will change, but I don't think the basics of being a good lawyer will ever change.
And I hope not. And you may be the first person I ever heard say that they brought their own personal copy machine to a warehouse, Judge. But that is those tenets right there. We started off this episode talking about the core tenets that you brought out in your Florida Law Review article, and here what you're talking about is really just codifying that. You're really bolstering this thought that in order to be a good lawyer, like you cannot forget the basic building blocks. What makes a good lawyer, and I think that's so important. We also started this episode talking about how, at least, our collective belief is that everybody should be hanging these core 10 tenets, on their walls of their offices. You have both in your published case law as well as your published thought leadership. I've seen you, speak before. What do you want your legacy to be, Judge?
I've been involved in this system a long time. I started out my career as a police officer, and I would work the street. And then I became an attorney, and I tried tons and tons of cases, a lot of very, very high profile cases, some not high profile, some short and small, some very large, some lasted many months. And now I've been on the bench 13 years. and I'll stick around for a while longer. I think what I would want my legacy to be is that I have tried to do everything I can to make our system of justice, whether it's civil or criminal, a more fair system of justice to all the parties. You know, every party deserves a fair hearing and a fair resolution of their case. And I've often said that the way justice works is if you have competent lawyers who appear in front of a fair, even-handed judge who both do their job. You know, if it's a criminal case, the prosecutor does his or her job, the defense lawyer does his or her job. They pick if it goes to jury trial, they pick a fair jury. The jurors do their job. They fairly evaluate the law and the facts. They evaluate what the facts are and apply the court's law to those facts. If all that happens, whatever the end result is, in my view, is justice. And so I think really my legacy would be that I would like the lawyers to understand how important their role is. I have had clients 15, 20 years later contact me, and in a case that I never thought was that important, tell me how the resolution of that case helped them dramatically, change their lives, whatever it might have been. And sometimes lawyers can get caught up in the day-to-day drudgery of the law practice and the hard work and forget how important their role is. So I guess my legacy would be to make the justice system better and to try and encourage the other participants in the justice system, both civil and criminal, to do their best to make the system better. And that means they have to do their role at a very high level. And if everybody performs their role at a very high level in every case, then the end result of those cases is going to be fair justice. I mean, that's just the way I see it. You may not agree with the end result, but if everybody has done their job properly, the lawyers, the parties, the judge, the jurors, the end result, in my view, is justice.
Judge Matthewman, what a way to close out this episode. It's really been a privilege. We are both very grateful to have this opportunity to speak with you. And we really are going to do our best to amplify your message in this episode to as many lawyers as we possibly can. Judge Matthewman, thank you for your time today.
All right. Thank you. And good talking to both of you, Daniel and Brandon. Thank you very much.
Thank you.